Hey you guys, it's your girl Ayana, aka the Crafty Notary, and I'm back with another video. Today I am talking about wills and trusts. And this is one of those topics where it kind of, especially with trusts, you kind of get confused on what's what and what we should do. So I want to break down what they are. Notarizing them is actually the easy part. But sometimes we want an understanding of what we're notarizing before we actually do it. So first of all, I want to say that thank you so much for subscribing to my channel. Thank you so much for watching. This has been an awesome experience and awesome journey, and I absolutely love educating each and every one of you guys who request my help. So with that said, let's just get into the video. So not understanding how to properly notarize a will or trust can result in damaging someone's affairs or the signer's affairs. And we must remember that even though we don't advise on how to sign a will or a trust, even assisting the signer in notarizing the will or trust can open us up for liability, and it's a risk for liability. Now, where did I get that from? That came direct from the Notary Primer. Okay, so I did not make this up, and you can't dispute me because it's in the primer. And so you want to be careful that not only on the will and trust, but even the power of attorney, that you are not helping them complete that form in any way, shape, or form at all. You're not telling him initial here. You're not saying, none of that, or you're not even reading it and letting them decide. That form should be completely filled out when you get it, with the exception of the signatures. And all we will do is witness the signatures being made and then complete the notarization of the document. So if there's any doubt on the signer's behalf or the witness's behalf, even where they don't understand what they're signing or they don't know how to fill it out, they need to seek legal help. They need to talk to an attorney. It is not the notary's responsibility to even suggest what they should be doing. They need to talk to an attorney. I don't think I can iterate that any clearer or with any more seriousness. We are not assisting them on filling out any of these documents. Power of attorney, living wills, trusts, any estate planning things, they need to already have them completed. They need to already understand what they're signing. And we are just watching the signatures go on the paper and then notarizing the document. All right. Now, we can notarize a document whether or not an attorney prepared it or if the signer prepared it themselves. There's no stipulation for that. Now, let me back up a little bit. I am talking about the state of Florida only. I only operate in the state of Florida. So if you're watching this and you're outside the state of Florida, all you have to do is check with your state. And if you go on to the National Notary Association.org and pick up their primer, this is the Florida primer, but they have a primer for every state. So if you pick up the primer, and it will be in there for you. All of the laws for your state will be in there for you. So in order to notarize a will, the signer must be present. Okay, obviously, they have to be present, and they have to appear to understand the purpose of the document. So right there, we are checking for capacity. And that is one of our jobs as a notary, is to check for capacity, the ability for the signer to understand what they are signing, because we don't want anybody signing anything under duress. The signer must also produce ID, acceptable ID. So that would be whatever is acceptable in the primer for our state. So here in the state of Florida, you got military ID, you got driver's license, state ID, passport, those types of things as ID. Now, the signer can also be personally known to you. However, you cannot benefit from the transaction, so you can't be the beneficiary. But if it's a friend of yours and you personally know them, you can notarize for them without them having to produce acceptable ID. Now, the caveat is that if they do not have ID, they cannot use credible witnesses in order to sign a will. Okay? So they either have to be known to you personally or produce acceptable ID. They cannot use a credible witness to identify them to you. Okay? That's a liability. Someone else is going to tell you, oh, yeah, that's who they are. And you sign that and someone's affairs are attached to this document. All right? The document typically contains jurat language, or if it does not have any notarial language, the signer must instruct the notary to, my dog, to attach a jurat certificate or use jurat language on the document. Now, we have to remember, we cannot choose the notarial certificate. So we can tell them the difference between the both of them, the acknowledgement and the jurat. Where do you find that? In the primer. It's in there, and it's in one of my other videos. Go back and watch it. And then we can sign. All right. Now, wills also require witnesses in the state of Florida. The notary can be one of the two witnesses as long as the witness's signatures do not require notarization. Witness notarization is on a separate page. So, for example, on the mortgage, we usually see two witness boxes, and then we see the signer. Two witness boxes, and then two witness blocks, and then the notary language at the bottom. We're notarizing the signer. We're not notarizing the witness blocks. From what I've seen so far, whenever we are notarizing the witness signatures, they're on a separate page from the signer's signature, or they're in a separate block. So it would be signer, notarial block, witnesses, notarial block. And that way we know we are notarizing the witness signatures. But you want to be clear on whether or not the witness signatures are being notarized, because you cannot notarize your own signature. So if that is the case, they need two witnesses and not one. All right. Witnesses in the state of Florida can be any competent person. Now, competent, there's a definition for competent. Let's look it up. I should have done this before, but let's look it up just for the sake of this video. So the definition of competent is having the necessary ability, knowledge, or skill to do something successfully, efficient and capable, acceptable and satisfactory. This does not speak to age. Okay, I just want to make that note. It does not speak to age, but they must understand what they're signing. They have to be competent. Yes, they must be competent of that. Just checking. Yeah. So it could be any competent person. So any person that is competent of signing as a witness. There is no mention of age. However, I think that, to be safe, I would think someone of legal age would be required or would be best practice. So witnesses cannot have any interest either beneficially or financially, and they must be impartial. Okay, now there is a type of will that is called a self-proving will. And these wills are designed to shorten and simplify the probate court process. So typically the way it works with a will is the person passes away, the family presents the will to the court, and if there's witnesses there, and it's not a self-proving will, the court will have to reach out to those witnesses and confirm that they signed in the presence and that was their wishes. A self-proving will is where the signer and the witnesses take an oath, an additional oath, and sign an affidavit stating that they signed in the presence of one another. Okay? So without the oath and affidavit, typically if there's an issue proving the will, the witnesses have to be located during the probate court process, right? So that's typically how the will works. So when it's presented to the court, if it cannot be proven or if there's any doubt with it, they're going to try to find those witnesses. All right. And then there's also a living will. And a living will is not an actual will, but it's a written statement of the signer's wishes pertaining to medical treatment in the event they cannot make decisions for themselves. So it's not a will in the sense that the person has died. It's a statement, as I said, that speaks to what they want to happen when, in the event they are not able to make decisions for themselves. So do they want to be resuscitated? Do you want nourishment and things like that withheld? So those are the kind of things that are in a living will. And again, we do not offer any legal advice or advice, period. No advice. We cannot assist in preparing, completing, ensuring whether they understand the document. If they don't understand it, they don't know how to complete it, it's not prepared, and they can't prepare it before you because they don't know how, then you're going to have to reschedule the appointment. You can't proceed. They're going to have to seek advice from an attorney or whomever else they want to seek advice from, but it cannot be you. Okay? And you will need to end the appointment. So that's that on wills. Now, trusts, the only thing I want to touch on trusts are the two different types of trusts, because everything that really applies to wills applies to trusts as well, because these are all estate planning documents. And I do want to mention that wills and trusts and power of attorneys can be notarized remotely. So that there was a law passed where we can sign them remotely, doing remote online notarization. So now the two types of trusts. We have a revocable trust or a living trust, and you have an irrevocable trust. So a revocable trust is just the way it sounds. It's able to be revoked. However, it's not just that straightforward. So a revocable trust is also called a living trust, and it's an agreement that the trustee makes, that the person makes during their lifetime for the benefit of themselves and then the benefit of someone else after they die. This is used to avoid probate altogether. So if you have a revocable trust, probate gets avoided altogether. With just a will, it could still go through probate. Now, with a revocable trust, you will have a last will and testament, and that would designate everything going into the trust. And then whomever is named beneficiary of the trust will get the stuff. Okay. So it's revocable because you can change it. So let's say you have Mary Sue as your beneficiary and she gets on your nerves one day and you want to change it to her brother, Harry. And then you can go ahead and do that and make those changes. Now with the irrevocable trust, it's just the opposite. You're designating items into a trust for the benefit of someone after you die, but it cannot be changed. It cannot be revoked, cannot be changed, it cannot be amended. You can add people, you can't remove people. Once it's in writing, it's in writing. It's a done deal. That's it, and that's all. A lot of people use revocable or living trusts for property because you can live in the property. It's still yours while you're alive. And then once you pass away, now the person whom you designated benefits from that property after you're gone. So that's the way revocable and irrevocable trusts work. In the state of Florida, you also need 2 witnesses for a trust. For a trust, and it has to be notarized. So those are the major differences. And yeah, I think that's all I got in my notes. So I hope this video helped someone today. And drop a comment down below if you have any additional questions. Be sure to check out my new notary training by Ayana website. It is located at ayanalugo.com. There you can sign up for a free 15-minute clarity call where we can discuss whatever it is you want to discuss and get clarity on. You can ask me a question. We can create a quick plan for you. If you want to lay out your business plan from start to finish, like on what you need to do in order to get up and running, then you want to maybe opt for the 30-minute call. And we can do that as well. There's also other information there for you, some free, some not free. I have digital notary stamps and all of that stuff. And I forgot to mention on my last call, I do have a coupon code for anything that's on my website and my courses. It's Launch 10. So it's 10% off, Launch 10. I do have the A to Z loan signing course. It's live right now, ready for anyone to watch it who wants to know how to do a loan signing from start to finish. And so Launch 10 is the coupon code and it's ready for you guys to use. If you have any suggestions, drop them down below for any videos or whatever have you, drop them down below. And I will definitely get to them as soon as I can. I answer all comments, so please drop those as well. And until the next time, guys, I will see you. I'll see you. Have a good one. Bye.